I'm Sandra Astars. I'm a professor here. I founded the Arts and Entertainment Advocacy Clinic here at Scalia Law, and I'm a member of the CIP2 team. I'm Senior Fellow for Copyright Research and Policy, and it's my pleasure to welcome all of you to this panel on copyright licensing after the Warhol and the Internet Archive rulings. And I'm going to start by summarizing some key points about the cases so the panelists don't have to take up their time today doing so. We're talking about the Hachette Book Corp v. Internet Archive case. And in that case, the four major book publishers sued Internet Archive. They claimed that Internet Archive infringed their copyrights by scanning print copies of their works and lending digital copies to users without the permission of the publishers. Internet Archive claimed that it makes fair use of the works. It employs a system that it calls controlled digital lending, whereby Internet Archive acquires print copies of books, digitally scans them, and distributes the digital copies while keeping the print copies in storage. Many of the books that are included in Internet Archive's website are public domain works, but the website also includes millions of books that are protected by valid copyrights. All of the works that the publishers sued on are copyright-protected works for which the publishers also offer licensed ebook alternatives. And among other claims, the publishers asserted that Internet Archive was, through their model of scanning and digital lending of works, superseding the publishers' licensed offerings of ebooks in the marketplace. And in March of 2023, the Southern District of New York ruled for the publishers. And this is essentially what the court held. They ruled that Internet Archive's use was not transformative because it did not add anything new to the works. It merely superseded the originals. It also looked at Internet Archive's nonprofit status as an issue in the case, and it cited the Supreme Court in Harper Row and quoted them, saying the crux of the profit-nonprofit distinction is not whether the sole motive of the use is monetary gain, but whether the user stands to profit from exploiting the work with or without paying the customary price for the work. The court was also unconvinced by Internet Archive's arguments that its activities furthered the goals of the first sale doctrine, which is limited to distribution, not reproduction of works. The parties negotiated a final consent judgment that ended the lawsuit subject to Internet Archive's right to appeal. The judge clarified that that consent judgment does not concern books that are not yet available from the publishers in electronic format because those issues were not briefed or considered by the court. Internet Archive is appealing the case to the Second Circuit, and it has recently been sued by music publishers over the archive's digitization of vintage records. The second case that we're talking about today is Andy Warhol Foundation for the Visual Arts versus Goldsmith, which was decided by the Supreme Court in May. For anybody who's managed to miss the conversation about this case, it concerned the Warhol Foundation's licensing of a Warhol work that incorporated a photograph taken by Lynn Goldsmith of the rock star Prince. The photograph was originally licensed for Warhol's use as a reference photograph, and the license came with various limitations, but the agreement was between Goldsmith's agency and Vanity Fair, not Warhol, and there's no evidence that Warhol ever knew of the terms of the license. Warhol ultimately used the photograph to create a series of 16 works that are now known as the Prince series, and one of those works, Purple Prince, was used in the magazine as planned, and the rest remained unpublished. When Andy Warhol died in '87, the Andy Warhol Foundation for the Visual Arts assumed rights in his work. And after Prince's death in 2016, another work in the series was eventually licensed by the foundation to Condé Nast for use on the cover of a commemorative magazine that honored the musician. And they did so without first seeking permission from Goldsmith. Miss Goldsmith became aware of the existence of the additional works at that time and contacted the foundation alleging copyright infringement. The foundation sued Goldsmith, seeking a declaratory judgment of non-infringement or, in the alternative, asserting fair use. Goldsmith countersued the foundation for infringement, and the case proceeded from there. So in July of 2019, the federal court for the Southern District of New York ruled in favor of the foundation on its fair use defense. The court was focusing mostly on Warhol's use of the photograph in creating the image, and it found it to be transformative because Warhol was portraying Prince as iconic and larger than life, where Goldsmith's work had portrayed Prince as a vulnerable human being. And Goldsmith appealed that decision. So then in August 2021, the Second Circuit reversed and found in favor of Goldsmith on all fair use factors. But here the court's analysis still focused on Warhol's use of the work rather than on the foundation's later licensing of the works. In December of 2021, the foundation sought cert to the Supreme Court challenging the Second Circuit's decision. And on May 18th of 2023, in a 7-2 opinion, the court held that the purpose and character of the foundation's licensing use of orange prints to appear on the cover of Condé Nast magazine, honoring the musician, did not weigh in favor of a fair use defense under Factor 1. It was an interesting split in terms of who was with who on that decision. It was a 7-2 split. Justice Sotomayor writing for the majority. Justice Gorsuch and Justice Jackson joining him wrote a concurring opinion, and Justice Kagan and Chief Justice Roberts issued a strongly worded dissent. So, with that background, and granting all of you on the panel the absolute right to amend and expand on my summary of the cases, let me turn to the panel and ask each of you to help answer this overarching question that our panel is framing up today. How did the two decisions impact copyright and licensing? And so I'm going to start with Kevin Amer. And Kevin is Chief Legal Officer for the Authors Guild. And I have to say, actually, before I introduce all of these folks, and as I introduce all of these folks, we are really honored today to have what I've been referring to as my C-suite panel, because everyone on this panel is either a Chief Legal Officer or an Executive Director of a major organization involved in the debates in these cases. So we're really honored to have these folks speaking to us today. So Kevin is going to lead us off, and Kevin is Chief Legal Officer for the Authors Guild. And the Authors Guild is the oldest and largest professional organization for published writers in the United States. So Kevin, what have the Warhol and Internet Archive cases told us about the role of transformativeness in the fair use analysis?
Great, thanks so much, Sandra, and it's good to see you all. Good to see a lot of familiar faces here. So I think, and obviously this audience knows a lot about the Warhol case. I think, though, that, one of the most important takeaways from the case is that it really clarified that the fair use analysis has to focus on the use at issue, right, and the extent to which that implicates an exclusive right. As opposed to looking at the secondary work itself and sort of determining whether that secondary work could be considered transformative and then letting that sort of carry the rest of the analysis. Some of the earlier cases, in the transformative realm, tended to sort of focus on the secondary work itself, right? And once it was determined that work was transformative in the court's view, that would sort of dictate the rest of the analysis, because in Campbell, the court said that there's no market for transformative uses, and so the finding of transformativeness would essentially dictate the result in a lot of cases under the other factors, including the fourth factor. If you look back at the Carey versus Prince case, different Prince, this was the case, obviously, where Richard Prince, an appropriation artist, used images of Rastafarians as part of an art exhibit. The language of that opinion really is talking about sort of the extent to which the Prince artworks manifest a different aesthetic from the Carey photographs. So it wasn't looking sort of with whether there was a transformative purpose so much as whether the secondary work could be called transformative. Similarly, there's the Seltzer versus Green Day case from 10 years or so ago. This is where the band Green Day used a street art image as part of its concert footage. There, the Ninth Circuit was, moved by the fact that in the Green Day use, there were images of religion that were superimposed onto the original image, and so it was important to the court that the original image said nothing about religion, but the secondary use added this new meaning or message. And because of that, it said it conveys new information and aesthetics, et cetera, therefore it's transformative. So obviously there are a number of problems with this. I think one of the most obvious is that it sort of puts judges into the role of being art critics, right? And that's something that we've, I think, cautioned against for a long time in copyright law. It also conflates the transformativeness inquiry with the derivative works right. So I think Warhol provided helpful clarification there. I think the other important aspect of Warhol was that it really clarified the transformativeness, and this is related to what I said before. It's not a standalone factor, but it's on a sliding scale, right? The court expressly said the transformativeness is a matter of degree, and it has to be balanced against commercialism and whether, the extent to which the secondary user has a justification for the work. So again, previously courts seemed to look at transformativeness, and they would make the determination, well, if the secondary work is different enough, that sort of carries it across the line, and we don't have to they, would consider commercialism and other factors to some extent, but I think in a lot of cases, once that transformativeness determination was made, it pretty much carried the day. So I think that Warhol was helpful in that respect. And then just lastly on Internet Archive, I think that case was also valuable in that it sort of re-emphasized that the transformativeness inquiry has to look at the entire purpose of the use. So you look at the secondary user's overall purpose as opposed to just sort of focusing on the copying itself and looking at whether that might be transformative. The Internet Archive relied heavily on the Sony Betamax case. That predated the transformativeness concept. But the argument basically was that the scanning of books by Internet Archive was at least as transformative as what was going on in Sony, the recording of television programs by home viewers. And the court rejected that, basically emphasizing that the analysis has to look at the Internet Archive's overall purpose. So, the court said Internet Archive is unlike the home viewers in Sony who engaged in the non-commercial, nonprofit activity of viewing television programs. The home viewers were not accused of making their television programs available to the general public. Although Internet Archive has the right to lend print books it is lawfully acquired, it does not have the right to scan those books and lend them out en masse. So again, the focus is on the purpose of the use and not just on whether the resulting digital copies themselves might be considered transformative. I think I'll stop there and answer any questions.
Okay. So I'm actually going to have the panel answer first round of questions, and then I'll come back and re-engage and then go to the audience, if that's okay. So I want to move to Terry Hart, if I could. And Terry is General Counsel for the Association of American Publishers. And the Association of American Publishers represents the leading book, journal, and education publishers in the United States. So Terry, if I can ask you, what are the implications of the copyright, for copyright and licensing from these two decisions?
Happy to answer that. Thanks, Sandra, and thanks to CIP2 for inviting me here. So let's go back 1 year. I think there was, in the view of some, there were storm clouds on the horizon. This was before either of these decisions came out. The Supreme Court, though, had agreed to review transformativeness in the Warhol case. and briefing on motions for summary judgment had begun in the Internet Archive case. So both of these cases raised really critical issues for the organizations that I represent, book and journal publishers in the trade, educational, and scientific and scholarly publishing sectors. We filed an amicus brief in the Warhol case, and we explained there that divisible copyright interests and downstream markets are fundamental to copyright protection, and they're the basis by which all kinds of formats and adaptations are licensed, including ebooks and audiobooks, which are very important to a lot of our publishers. And Andy Warhol Foundation's position that it was asking the Supreme Court to adopt risked undermining this really important foundation. Internet Archive even more directly threatened to usurp and eviscerate these digital markets, not just for books, though. As other amici briefs pointed out, it would extend to all types of copyrighted works. So fast forward to today, we have both the decisions out, and from the perspective of publishers, looking at the state of copyright licensing derivative works, based on how they had historically understood them, very little has changed due to these decisions. But compared to what could have been, I think the decisions were certainly very much welcome. Both of these decisions reinforce the importance of the exclusive rights framework, its role in enabling marketplace and licensing practices by providing control over how, when, to whom copyright owners make their works available in a variety of formats, offline, online, and including market-enabling terms and conditions. I think the Supreme Court decision in Warhol really drove this home with this great quote that I'd be happy to share, where they said, "If the last century of American art, literature, music, and film is any indication, the existing copyright law, of which today's opinion is a continuation, is a powerful engine of creativity." In other words, copyright enables publishers and other businesses to organize around and to maximize profits through the creation and dissemination of creative and expressive works. It allows them to engage in many of the same types of product and pricing strategies that other businesses use in order to succeed in the marketplace. And this is only possible through the legal framework established by copyright, particularly the rights in Section 106. And I want to highlight some of the key features of those rights that I think are really important to making this whole thing work. One is that they're exclusive. The copyright owners themselves, on their own, have to make and bear the risks of the daily business decisions regarding their works. The rights are divisible, too. They could slice and dice them in any number of ways, which also contributes to the success. And finally, they're also interconnected. Right? Public performances of works may satisfy the demand for reproductions and vice versa. As I was thinking through this, I thought of the old metaphor of the bundle of sticks and thought that doesn't really capture how the exclusive rights and copyright works, right? If I take out the public performance stick, it doesn't really matter that I still have the distribution stick, or if someone else takes out the ebook stick, it doesn't matter that I still have the physical book stick. Instead, I think of it more like a house with a number of different doors. And so if I would break into your back door, you wouldn't be so happy if I told you, well, don't worry about it. You still have a lock on the front door. Things are fine. The Warhol Foundation decision reinforced this framework. It didn't address it directly, but it reinforced it. They said that fair use, as Kevin pointed out, fair use requires an analysis of the specific use of a copyrighted work that is alleged to be an infringement, and the same copying may be fair when used for one purpose, but not another. In other words, every use matters in copyright. Every use is important. Internet Archive's holding was premised on this framework. It informed the entire decision. For example, the courts talked about how format shifting is not fair use, and allowing format shifting, unauthorized format shifting, risks eviscerating the rights of authors and publishers to profit from the creation and dissemination of derivatives of their protected works. Elsewhere, the court said publishers don't price print books with the expectation that they'll be distributed in both print and digital formats. And so if I could offer one final observation here to round out this discussion, that's that Internet Archive, in my view, it's the latest in a long line of cases where defendants thought they had found a loophole in the exclusive rights protected by copyright, usually involving some form of first sale as well. These cases all involve defendants who offered a service that exploited copyrighted works without authorization. In each case, the defendants deployed some kind of technological contrivance in a way that didn't serve any business or practical purpose. The only purpose that this contrivance offered was to claim some kind of compliance with the Copyright Act and support the novel legal theory. So the cases I'm thinking of involve On Command, mp3.com, Zadiva, Aereo, which went up to the Supreme Court, VidAngel, and Redigi. And in each of these cases, courts saw through the technical sleight of hand and legal sophistry offered by the defendants. They rejected the idea that there are loopholes which permit unauthorized exploitation of copyrighted works in competition with the copyright owners, but minus the royalties authors are entitled to, minus the revenues to publishers that allow them to recoup their investments. The exclusive rights are not technicalities, but they're essential to the functioning of copyright system. In other words, the courts recognize those key features of Section 106 that make copyright the engine of creativity, and that recognition, my hope is, will give us the next century of American art, literature, music, and film. Thanks.
Thanks, Terry. So next, I'd love to hear from Dave Hansen, who is Executive Director of the Authors Alliance. And the mission of Authors Alliance is to advance the interests of authors who want to serve the public good by sharing their creations broadly. Dave, what are the implications for copyright and licensing from these two decisions in your view?
Yeah, thank you, and thank you for the invitation to be here. I think for starting with Warhol, it's important to understand a little bit of the framing of how this arrived at the Supreme Court, because I think it influences how we understand the outcome of this case and its downstream implications. So the petition for cert and the question presented in this case were really fascinating. Anybody who knows anything about fair use knows that there are 4 factors that the courts look at when you evaluate fair use. And when this arrived at the Supreme Court, the question presented was focused solely on how to deal with that first factor. And how to deal with this question of the purpose and character of the use, and in particular, things like commerciality and transformativeness. And so I thought that was really fascinating part of this case, because it at several points in the opinion, the majority opinion, it seemed like the court really wanted to talk about some other factors like the market harm and commerciality, but imported those sort of into that first factor. And so that's actually the first thing that I wanted to mention was commercial use. It seems like one clear takeaway from this decision is that the court has kind of re-emphasized the value or importance of evaluating the commerciality of the use. And we see some implications for that in the Internet Archive case that I'll get into in a moment. But over the years, if you look at Supreme Court precedent on fair use, I think what we've seen in the lower courts and their reaction to that is sort of a ping-ponging a little bit back and forth over the value and importance of that non-commercial, commercial distinction in the first factor. If you go back, for instance, into the 1980s with Sony versus Universal, a case about personal home recording, you got sort of one slant on commerciality, and then in Harper and Row, that was another case in the 1980s, it sort of swung the other way. And so what I think we're going to see in the lower courts, and I think we kind of already are seeing, is a resurgence of interest in really deeply evaluating whether a use is commercial or not under that first factor. So I think that's one important takeaway for kind of downstream use and licensing. Another, a little bit more connected to the theme of this conference and first sale, is that, as Kevin mentioned, the Supreme Court really refocused, especially, or at least in derivative works cases, the analysis from looking at the work to the actual use. And that distinction has some important implications for subsequent uses of derivative works that have been created without permission. So, the Supreme Court in this case focused really narrowly on this use of the Andy Warhol print being licensed for this magazine use. And mentioned at least one point in the decision about like how other types of uses of this work might have a different outcome. I think the examples given were, for example, a Warhol, the Prince Warhol hanging on the wall of a museum, and how that might be a different fair use case, right? That might have a different outcome. And so I think one important takeaway from this is that we need to scrutinize and dig really deep on those downstream uses of works that have not been licensed but are potentially derivatives, because we have to look at each of those uses separately to assess whether fair use applies or not. So in some cases, we may be able to categorically say, like, yeah, that always seems like it might be a fair use and seems like a pretty straightforward and fair thing. I think, a Warhol hanging on the wall of a museum is probably not a super controversial use. But there could be others where that line is a little closer. For instance, I've talked with documentary filmmakers who have some concerns about whether, if they're doing a screening of their film, does it make a difference whether they're charging people to come in for the screening or not? Is that going to be a fair use determination? So that, I think, is an important consideration. Another sort of messy thing I think that the decision raises is the copyright status of those new works. So Section 103A of the Copyright Act says that there is no copyright protection in any part of a work, in a derivative work, in any part of that work where the material has been used unlawfully. And so if you have a situation downstream where in some cases that work might be lawful because its particular use is lawful under fair use, but in other cases it's not, it does raise some complicated questions about the copyright status of that work. So then I guess the third point I want to make is with regard to Internet Archive. So I mentioned that commerciality seems like it has received increased importance following the Warhol decision. But the Warhol decision didn't really define what commerciality means. It was a pretty clear case, and so the court didn't have to go far into that. But in the Internet Archive case, the definition of commerciality is a lot more important for figuring out, and I think much more contested in that situation, in that case. And so one of the outcomes of the district court opinion in that case was that the court concluded that Internet Archive's activity actually was commercial. And part of the logic there is that although Internet Archive is not charging people to gain access to the books that it is lending on its website, it is gaining increased attention to its website, it is getting increased donations on its website, and so that type of activity is indicative of commercial use. And that raised alarm bells with lots of nonprofit users of copyrighted works, because to them, it looked like very hard to think of any type of use that they're engaged with that doesn't raise those same sort of commercial use arguments. And so I think they're very concerned about what this will look like if that rationale stands, particularly in light of Warhol and potentially an increased emphasis on that commercial, non-commercial distinction in the overall fair use analysis.
Thanks, Dave. And I am going to end with Karyn Temple, and it's an honor to end with Karyn. She is Senior Executive Vice President and Global General Counsel for the Motion Picture Association. MPA is the leading advocate for the film, television, and streaming industry around the world. But prior to joining MPA, many of you will probably know that Karyn was the 13th United States Register of Copyrights. So Karyn, you represent the MPA, and although your industry, unlike your co-panelists here, was not directly involved in either of these decisions, it's clearly impacted by them. and indeed how the decisions might impact derivative work markets and licensing in the motion picture industry was very much on the Second Circuit's mind and on the Supreme Court's mind in Warhol as the opinions were drafted. So what are your thoughts about how the decisions will affect copyright and licensing generally, and any specific markets that you want to comment on?
Yes, and thanks, Sandra. It's happy to be here. I will say a little caveat that I am speaking only as a copyright nerd and not on behalf of my studio specifically. I have 2 points to make, one of which I think has already been really made well by both Terry and Kevin, but I just want to reiterate, and then another point that really looks at Warhol a little bit differently. So the first point I wanted to make was that I personally believe that Justice Sotomayor and the opinion single-handedly saved the licensing for derivative works that could have gone away if not for that opinion, given the way that courts had been looking at transformative use. It really made clear that transformation is not any longer a get-out-of-licensing-free card, which is something that, again, many scholars thought had occurred with the way that cases had focused on that first fair use factor. The second point that I wanted to discuss was just the social justice aspect of the opinion. When I first read it, I really actually was amazed by Justice Sotomayor's tone and some of the things that she wanted to highlight, and the rejection of any consideration of the status of the artist within his or her market or the art market more generally as a basis to find for fair use or not fair use. I think that is really an important recalibration in terms of how you assess the various uses and who is using or not properly the creative work. So as to the first issue, as most of us know, the first factor became kind of that single issue that all of the courts had looked at that really kind of read out, personally to me, the requirement that in the first factor you consider the commercial nature of the work. I think that courts were essentially ignoring largely the commercial uses of the work. And as a result, they were giving very, very short shrift to the fourth fair use factor in terms of the effect on the market, which the Harper and Rowe case said was the most important factor, but it seemed to have kind of just gone away, over many years. There was an actual study that was done in a law review article out of Stanford University, I think in 2019, which analyzed fair use cases and noted that of the cases where fair use was found and where they found a transformative use, 90% of those cases also found that the fourth fair use factor also favored the plaintiff. And so I think, essentially finding that once you find transformative use, you're not going to find a negative impact on the market. And many of the amici, I think, in the Warhol case pointed out that if you analyze fair use in that way, where you're just focusing on transformation and you're just asking a simple question, did the artist add something new, you are essentially getting rid of the derivative work right. I mean, that is literally what how you define the derivative work, right? It is adding, and adapting and adding something new. So I think by focusing on the commercialism aspect of the first factor, and also if you look at the Second Circuit's decision that the Supreme Court affirmed, which focused on the fourth fair use factor, I think we're now back to a more balanced approach to fair use that allows licensing to exist and the derivative work right to actually exist and a strong marketplace to be developed. So I think without, kind of doing that turn, we would really be in a very difficult position in terms of, being able to continue to have a really, fulsome derivative work licensing market. So that's my first comment. The second is just focusing again on the social justice aspect of the opinion from, I think, a justice who really personally understands the elitism that has undervalued segments of the artistic community. I think this is especially true when you compare Justice Sotomayor's opinion with Justice Kagan's dissent, as well as if you look at lower court opinions like the Blanche versus Kuhn's case and the Prince versus Carrier case, that really focused on the status, the celebrity status of the artist in assessing whether there was a harm to the market and what that harm would look like, and essentially saying, well, if this is an artist who is well known and who and can sell their artwork for a lot of money, then their appropriation or use is more likely to be found to be fair. And I think footnote 19 of the opinion in the Warhol case really does just, it's one footnote, but it really, I think, honed in on this point. She noted that, looking at the status of the artist would create a kind of quote-unquote privilege that has no basis in copyright law. She also, when she discussed the plaintiff in the case, she emphasized that Goldsmith herself was a, very, good artist, I guess you could say, or well-known artist in her own way, that she was one of the few female photographers, that she too was a quote-unquote trailblazer along with Warhol. You can contrast that with how Kagan discussed Warhol. I think she spent maybe many, many pages talking about how great Warhol is. She, noted the, quote, eye-popping silkscreen. She said, you've probably heard of Warhol, and you've probably seen his art. And I'm going to say that there are actually a lot of people in the world who might not have seen Warhol. And if your assessment is that you're just focusing on your audience and your assumption that we've all seen Warhol and love him, that is not really, I think, a great way to assess whether something is fair. Then she, goes on to talk, kind of criticize the majority opinion in a way that I personally felt was a little bit condescending. So I'm going to stop there, but just note that, I think that this was just a really good recalibration of fair use in both of those ways, both allowing for there to be a strong licensing market, a strong derivative work market, and also really getting rid of this celebrity plagiarism exception that one of the court opinions below mentioned, by making sure that you didn't really focus on the status of the individual artists in their particular markets.
Thank you, Karyn. So I have a couple of questions for the panel. I imagine there are questions from the audience as well, so you can gear yourselves up to get to microphones for those in just a couple of minutes. But I'd like to just have each of the panelists who wishes to do so comment on, just in general, whether you think any of the prior fair use cases would have come out differently today in light of Warhol. I think all of you touched on aspects of Warhol and how the Warhol decision was different in approach to previous cases, but do you think any of the cases would have come out differently?
Yes, definitely. I don't know. I think Google Books would have probably come out potentially even differently. Definitely Carrier and Blanche versus Kuhn's.
Although the Justice Sotomayor says it wouldn't have come out differently.
I actually think that it would have. But
Anybody else? Kevin, you look like you've got a
Oh,
thought.
well, I mean, I think the two that I mentioned probably are the leading candidates that I could think of. Certainly Carey versus Prince. I mean, even the Second Circuit's opinion in the Warhol case sort of signaled that has come under some criticism. I think it's hard to reconcile the court's analysis in that case with the Supreme Court's analysis in Warhol. I mean, I completely agree with you, Karyn, about, I think there's always been I've always felt some discomfort with the analysis in that case about sort of Prince's works being desired by sort of a different type of collector than Carey's were. And then I think probably the Green Day case would also. I mean, as I was saying, I think that case was so much focused on whether there was a new meaning or a new message added to the work. I think that type of analysis probably doesn't survive after Warhol.
Dave, do you have thoughts?
Yeah, I mean, I agree, especially on the appropriation art cases, and in particular, a point that Karyn made about this sort of celebrity artist sauntering in and saying, like, of course it's transformative, I'm Warhol. That kind of thing, I think, will not fly anymore, and I think that those cases illustrate why that is a pretty bad approach to assessing transformative use.
Yeah, I mean, I would have to say I would agree on Carey Seltzer. But it just occurred to me, the interesting question is, what about the Sconey Nation case in the Seventh Circuit? And I say interesting because there, Judge Easterbrook actually criticized Carey pretty directly and criticized this idea of transformativeness, but then at the end found fair use of someone who had taken a photograph, silk screened it onto a T-shirt and sold the T-shirt, which in my mind, does bear some similarities to what happened. What was that issue in the Warhol case? So, but other than that, yeah, I think I looked at this from the perspective of some of the book cases, not the Google book or the functional transformation, but sort of the one-to-one transformation. I think those, by and large, would have come out the same way. It's mostly in the appropriation art, the visual art space, where I think there would have been maybe different outcomes.
And maybe my Google Books is a little stretched. Maybe that's just a hope and a fantasy. But the reason I actually say it is also because I think that in the case, the court really ignored the fact that Google was using the works for a commercial purpose. It was back in the day when everyone assumed that anyone on any of these internet companies were all doing this, for almost a public service reason. And so it really ignored that one of the reasons that they were copying every book in the library was to make their search engine better. And that is a commercial advantage for Google. And so I think, again, focusing on the commercialism in the first factor as well as the potential market would potentially affect that analysis in that case as well.
So my second question to all of you is, how do you think the decisions in either or both of these cases might be relevant to emerging licensing markets in things like text and data mining or, relatedly, AI, everybody's favorite topic? Anyone want to take a shot at that? Sure.
I'll start things off. I mean, I still think you have to read a lot of tea leaves to see how courts might approach these questions, particularly, the way we tend to look at them most often is with the ingestion of copyrighted materials to train AI models, particularly generative AI models. But I think if you're a developer of an AI system and you see both of these cases comes out, certainly nothing in there helps you. And to some extent, I think maybe narrows your claims to fair use there. On the commerciality point, on the justification point that Justice Sotomayor emphasized in the Andy Warhol decision. So, again, we'll have to see, but I think after these decisions came out, I think it's a much higher hurdle for AI developers who are hoping to rely on fair use to clear.
Yeah, I would just add that I think that, again, this, rehabilitation of the fourth fair use factor and effect on basically the potential market is something that is now going to be a focus in some of these cases. And so you don't necessarily have to prove so strongly, that there is a current existing licensing market that you are actively engaged in, but the fact that maybe you are you have a potential market. I think in the past, in the cases before Warhol, they both ignored a potential market and the existing market, quite frankly. Whereas now you can say I might have, or I would have licensed my works to an AI company to be able to train or generate, subsequent works. So I think that it's going to at least be a more important factor that will be considered in a way that it might not have been considered pre-Warhol.
So I suspect that Dave might have something to say about that, given that issue recently came up in the Hachette case post judgment, right?
Yeah, the licensing issue, that was a big issue in the scope of the injunction, and the availability of those works already as an ebook, I think, was an important distinction. And I think supporters of CDL, or controlled digital lending, and the libraries maybe looked at that as like, oh, okay, if a book isn't offered as an ebook, then we're okay, but that's not really what happened. It was just that it wasn't briefed, and so the court declined to issue an injunction around it. So I think it's still a pretty open question. To get back to your original question, though, of the effect on emerging markets like text data mining and AI, we were given that question beforehand, so I got to think about it a little bit. And my initial reaction is I do think it's hard to kind of read the tea leaves. I don't think either of these cases is particularly directly relevant to those uses. But one takeaway from Warhol, as we've discussed, is that it really refocuses and asks us to look at the use and not the works that are coming out the other end. And so in a way, I think, again, it's not strong, but I think it actually supports some of the outcomes in Google Books and HathiTrust and these other cases that focus on functional uses to say, yeah, that's the right thing, is you need to be looking at what that use is and not kind of works that are, not the particular works that might be coming out of that. So again, I don't think my main takeaway is I don't think that either of them have a whole lot of relevance, though, for those types of applications.
I'll just add, I think, Warhol also, I think, provides counterweight, so to speak, to the Google versus Oracle case in terms of transformativeness. I think, when that case came out, there was a lot of concern about Justice Breyer's language about, the public benefits that purportedly were advanced by Google's copying. The fact that there was language in that opinion about how because Google did the copying to develop a new and innovative product that would benefit the public at large, that weighed heavily in favor of transformative. And I'm going to take your lead, Karyn. There's an interesting footnote. We've got to look at the footnotes in Warhol, where the majority distinguishes Google Books by saying Google versus Oracle did not hold that any time a court or a justice determines or believes that a use or the result of copying is somehow innovative or interesting, that necessarily makes it transformative. And again, the inquiry needs to be broader taking into account the overall purpose and the extent to which the activity may have a substitutional effect or interfere with potential licensing markets.
Yeah, I think the point that I took away from the discussion about the Google v. Oracle decision was that they were making a procedural point as to how you analyze the case, what process of analysis you go through, right? Rather than just, oh, it looks like there's a social benefit, right? Because we can think of a social benefit for pretty much any new technology, and art for sure, right? Like we all want more art, So, all right, I want to turn to the audience and see if there are questions from the audience for the panel, because I can certainly ask more questions myself, but the point is to engage all of you in conversation. So if there's a question, raise your hand and we'll get a mic to you. And if everyone is being shy, like students sometimes are in class, I won't cold call on you, I will cold call on the panel. I will move back to the panel and ask, since we've been talking about the delineation between transformative uses and derivative works, that the decisions, and in particular Warhol, crafted. Do you all believe that the decision resulted in a clear and correct delineation between derivative works and transformative uses? And if so, can you articulate it for us? Yeah.
No, I think.
We just don't want to tell you.
Right. I told you I was cold calling on the panel, so.
Yeah, I would say correct, yes. Clear, no. We'll have to wait and see, I think. I mean, that's the easy answer, is nothing the Supreme Court says is crystal clear. We'll just have to wait and see. I think the important thing they did, though, was they shone a spotlight on this distinction, and that'll serve as a speed bump so that courts don't have the temptation to sort of speed through and say, oh, it's transformative, therefore this supports fair use. They actually have to pause and say, oh, maybe it's transformative, but also derivative works are also transformative, and we have to have a more nuanced, more complex analysis here to make sure it's the type, either A, the type of transformation that's rightfully within the exclusive rights of the copyright owner, or the type of transformation that would support fair use. So I think that is, at least at this point, where the decision is still fresh, is really the important part, is that they've shown this light on this distinction.
Yeah, I mean, I would agree wholeheartedly. I don't think that we're going to get a bright line rule. I think that they talked about just having to assess both the transformativeness and the use and the balance, and also again, emphasizing that you have to look at all of the fair use factors. But I do think, some of the language they used, in talking about transformative use. For example, just emphasizing again that new expression is not alone sufficient, and that every derivative work again is going to add something new. I think it will help because we were going down a path where that you would have completely swallowed the derivative work right. So now at least there's an arguable chance that you can make, a distinction between when this is new and it's fair use, and when something's added and new and it's a derivative work. But it's going to be interesting to see how lower courts actually interpret Warhol, and what level of new expression and what type of new expression now they're going to look at to assess whether something is transformative or not.
So in terms of clarity, I guess one way of judging that is to see how creators and lawyers who work with creators have reacted to it. And I guess my experience so far is that it hasn't really moved the needle. I mean, fair use is complicated, and it always has been. And so I don't know that it has added a whole lot of complexity beyond what was already there. Or it certainly hasn't clarified, though, either. I guess the one reaction that I have seen, and maybe this is just like, oh, there's a new decision, so I need to be careful. But I have seen more hesitation on the part of creators who are incorporating works of others into their writing or other things that they're creating. And some of that is actually good, I think. It's sort of forcing them to pause and say, like, why am I really pulling this in? Like, what is the value of it to my work? And I think that that's a really healthy thing. But I've also seen a side of it where, I look at something and it looks like actually very, very clear. And there's a hesitation to use it just because of a concern that they might not be able to distinguish or explain themselves well enough. And so, overall, I guess this is sort of a lame takeaway, but there hasn't been much of a change that I've seen across the board with creators, except for that maybe little area of hesitation. But again, that could just be like the Supreme Court said something and we have to figure out what that is. So it takes a little while to work through the system.
Yeah, and can I just add to that point real quick? I would just say that I think the changing behavior for the artists is actually I think a positive thing and can create and open up more markets. So now if people are saying, okay, maybe I have to reach out to the original artist and get a license, that, again, helps that original artist to make a living. And I think if you look back at what was happening, in music, 10, 20 years ago in terms of sampling, people assumed that they could just take, just a little piece of music and they didn't have to get a license. And now you actually have a very strong sampling license market. So, behavior has changed with the recognition that you do have to get a license, and now people are able to, be paid more and have more incentive for the use of their works.
So, sorry, I was actually going to, I see questions, which I want to take, but I want to kind of push back on the thought that it's always a good thing to have people feel that they need to seek permission for everything they want to use. And I say that as somebody who advises independent artists and creators in a clinical setting. My goal is always to be able to have something to rely on when I'm advising, right? Whether it's a yes or no suggestion that I'm making to a client. And so the positive thing that I'm taking from the opinion is, whether it's super clear or not, at least I've got some guidance as to what was the court's thought process as they went through the fair use analysis. And I wrote a paper that's in the CLE materials that talks about the challenges of advising clients when all of the analysis has been done in the fair use context, and yet has always looked like a substantial similarity analysis that is often like a first impression, total look and feel, yeah, I know it when I see it kind of analysis that hasn't given a lot of guidance sometimes, right? It's transformative. That's all we have to say. It's transformative because I say it's transformative in some of the cases that Kevin cited to us. So that whether we think it's fully clear or not, I think there's at least some guidance that we can take away from it. I haven't seen a lot of change in guidance that's being given, but it's early days yet, too. So I sort of agree with the trend that all of you are noting. But Alex, were you asking a question? That would be great. Thanks.
Sure, yeah. So this has been fascinating. Thank you so much. I noticed in the panel description, you mentioned the question of kind of crossover implications for these cases when it comes to trademark in particular. That was really interesting to me. Obviously, we've seen a lot of development in trademark jurisprudence at the intersection of kind of fair use and First Amendment and expressive works. And then particularly in Bad Spaniels, I think a focus on this commerciality question, right? So whether and how the commercialness of the use impacts the speech content that it has. So I wonder if you could just say a little bit about where you see, I guess, Warhol and Bad Spaniels in particular intersecting.
Any one of you, feel free to jump in.
Well, I don't know if this is directly responsive, but I do think there was sort of a theme throughout the Warhol case and this goes to what you were saying, Karyn, about, well, this is a Warhol, and we associate certain, we sort of, as the public, we all know kind of what Warhol was doing. He was commenting on celebrity, and of course it's a Warhol, of course there's a new meaning or message. We know that just from the fact that it's a Warhol. And I think that, obviously copyright does not address, consumer confusion. That's what trademark does. So I don't know if there's a direct relationship, but I do think that the decision might be helpful in sort of clarifying, the differences between those two areas of law insofar as, the issue here was whether there was copying and whether it was fair use, as opposed to whether there, was some sort of consumer impression or something like that, which obviously is in the trademark realm.
What about the commercial versus non-commercial use? I think, Dave, you touched on that a little bit, the difference of the context of the use and the fact that we're analyzing particular uses of a work. So maybe the court would have come to a different conclusion if the orange prince image was hanging in a gallery instead of being licensed for use on the cover of a magazine commemorating Prince at the occasion of his death. And frankly, I'll throw in another twist, maybe also would have come to a different conclusion if the cover was for a magazine, not commemorating Prince, the artist, but talking about Warhol or, or having a different, topical message, right?
Yeah, I mean, I think that's a major, that was a major issue in Warhol, and in the Bad Spaniels case, commerciality factors in. It's a little different because, at least to me, that case is more about like when and how many hoops do you have to jump through to prove that you are okay with expressing the message that you want to express. And so the real issue in that case is, does the Rogers test kind of cut off the inquiry and just say the First Amendment allows this, or do you have to go through the whole likelihood of confusion analysis? And that commercial, non-commercial distinction is important for that. I do think, to Kevin's point, another piece of it that is important in that case is similar to in Warhol, you can't just show up and say it's transformative because I'm Warhol. I think in the Bad Spaniels case, that's a really hard case because it almost seems like the plaintiffs have showed up and said, it's a parody because I said it's a parody. And a lot of us are looking at it like it's a squishy dog toy. That doesn't seem as parodic as you might suggest. But I think that's a really important issue in that case as well, is that you really have to show what your message is and what why that expression is relevant, in that case more from a First Amendment perspective than anything.
Mark.
So thanks, great panel. So I think, like the panel, I read the Warhol decision as moving the inquiry away from message and meaning, which so many of these cases had started to focus on, and to, you have to show a further purpose to the specific use, which makes me think that in our discussion of licensing, there could be, and I think this is kind of what Sandra just said, there could be a variety of uses, some of which are okay, some of which aren't. We're no longer looking at, say, if Prince v. Karyn comes along again. This is one of my questions. If Prince v. Karyn came along again, Richard Prince, you might have to either sue him separately, different times for different things, which maybe practically wouldn't happen, but we'd no longer be looking at what does the work say, what was his intent, what's his story, what's his postmodernist, vision here. And instead, we'd say, okay, maybe is a museum, is loaning the work to a museum for public display, is that a different use from, say, putting it in, selling it in an art gallery to collectors, versus, of course, maybe even further, like licensing it in a commercial or something. So I think those are, do you think those probably are going to come out differently? And could it be that somebody like an appropriation artist could do it, could get away with some things, not with others, and maybe they could end up engaging in more litigation. Second quick question, what do you think about the change of context cases, like Bill Graham Archives, Perfect 10, Nunes, that's the Miss Universe contestant, where the whole work is used, and it was a new purpose, arguably, that was fair use, because the whole work was used, but just in a new context. So I was wondering about those cases, too, what you thought of those. So my two questions.
I mean, I'm happy to take the second question first, because I've thought about it too. I don't think Warhol directly addressed those cases, but I think it supports the decisions in those areas. So like Nunes, Bill Graham, the Fourth Circuit in the violent Hughes v. Brammer case went through a great discussion of those and categorized them, in its words, as documentary uses, right? They serve this purpose not of conveying necessarily the expression of the works, but of using them as sort of artifacts in works to explain either the history or scholarship or things like that, or in the case of Nunes, where you're reporting on the photo as opposed to using the photo to illustrate the story, and where there's a stronger claim to fair use if the news is about a particular photo, giving you a bit more latitude to copy that photo. So I think within the language of Warhol, which again really hones in on the sense of justification, of looking at why was the original work used, and the stronger the justification, the stronger the claim to transformativeness. I think you can maybe analogize those type of documentary uses to the types of uses that the court had in mind when it said there's justification, right? You can't write a history of, say, L. Ron Hubbard, where you're criticizing him without using actual quotes to show what you're talking about. Or the same thing with the Bill Graham, you're talking about a cultural history of the Grateful Dead, and you're using the movie or the posters of events to illustrate exactly the points that you're making in the text. So I think that would be my answer to the second question. Others had thoughts?
I'll just answer Mark, too, if I can use a moderator's privilege to say, this is why in my paper I've been arguing that you need to start with substantial similarity analysis to understand the work as a whole and understand the implication of copyright doctrines and copyrightability doctrines as a whole on the work before moving to fair use. I think the Warhol decision brings that home to us, because now when we understand that we have to understand fair use on a use-by-use basis, and we're only getting bit-by-bit answers. If you want an answer about the full work, you got to start with substantial similarity. You're never going to get an answer as to what you can do with the full work unless you do the full substantial similarity analysis first. So, John.
Yeah, thank you. Again, terrific panel. Just one quick thought before I move on to my question, which is, in addition to the substantial similarity analysis we have to look at, we have to remember that it's not a preamble. It's the first paragraph of the fair use test that talks about comment or criticism. And so we keep, right, in the same way that the court said the only question was the first factor, the first paragraph tells us a lot about the context for the fair use test. And that hopefully leads into my question, which is for the first 20 years of this discussion, there was a real love of both Congress and the courts towards technology. And so it gave us Section 230, it gave us Section 512 from a statutory standpoint, and it gave us Google Books and Hathitrust and a host of decisions that tended to have this technology exceptionalism. And Register Temple, you kind of alluded to this in the Google Book Project, but I'm wondering whether or not these two cases and the direction that they're suggesting, along with the Copyrights Office, call for a relook at Section 512, whether courts are going to start to think about a the real commercial activity that goes on in technology as part of that wholesome fair use analysis.
Yeah, I would just, I can respond. I would say, I mean, I think that's a really interesting point. You know, part of it, I think, has been that we've seen, you know, a different and a more, you know, a more probing inquiry into what technology companies are doing and why are they doing it than we saw at the beginning when, you know, the internet was just being developed. And I also think that the techlash, so to speak, that has, you know, kind of had on, that has kind of occurred in Congress and on the Hill and in the public has affected that analysis as well. I don't know if it necessarily means that the law is going to be wholesale changed because it's very difficult to change the law, and it's very difficult to come up with, I think, a consensus opinion as to how to do that. But I do think it does provide an opportunity, even outside of changing the law, for content creators and technology companies, for example, to work more collaboratively to figure out how to address things like piracy. When I did the Manji's lecture a few years ago, that was my whole point, which was, you know, we now have at least a more balanced court, a more balanced Congress, so both sides have something to lose and to gain, so to speak, from working together. And I don't know that legislation will change, but I do think that it potentially does change the overall online, you know, marketplace in a more positive way because you have both sides working together in a more balanced way.
So I think we are almost at the end of our time. I'm going to give each of the panelists a last opportunity for one wrap-up thought. So we've got 2 minutes, so split it up equitably amongst yourselves in this spirit of cooperation we've had here. I'll just go down the line, starting with Kevin.
Oh, well, I don't have much to add, but thank you all. This has been a great discussion, I think. I was thinking about the last question, you know, in terms of, you know, just the transformativeness issue that we've been talking about. And, you know, there is language in the Warhol opinion, something to the effect of, well, the degree of the degree to which you've changed a work in order for it to be transformative needs to be more than what the copyright owner gets to protect as part of its derivative work right. So it's still a question of degree. And yeah, that was sort of it doesn't seem to clarify all that much. I mean, I think it provides some clarification. You know, at the end of the day, I think it's worth asking how helpful this whole transformative concept is. You know, if what ultimately we're asking is, you know, is this the type of use that copyright owners ordinarily have a reasonable expectation of exploiting, or is it the type of thing that you know is not going to have an effect on their traditional markets? To me, that seems a whole lot clearer than looking at, you know, whether something is or isn't transformative, which just seems to create a lot of confusion.
Dave.
Yeah, I guess my concluding thought, we're talking about, you know, a case that went up to the Supreme Court, Andy Warhol Foundation, like big deal, even Lynn Goldsmith, like big deal photographer. And so these are parties who can litigate up to the Supreme Court. And some of the other cases that we've talked about, Google versus Oracle, sort of titans of the industry. But there's an awful lot of activity that happens in the fair use space that is engaged with by parties who have no resources at all to engage in any sort of litigation. And so they take a very, very risk-averse approach. And I think it's important to think about how the rules that get set in these kinds of cases trickle down to those parties who necessarily have to take a risk-averse approach. And I'm thinking about, you know, small-time authors, small-time film creators, nonprofit libraries and archives. And so, you know, I think that these cases do some interesting things to our understanding of fair use, but that downstream application that happens at that level, I think, is a really important consideration that often gets left out because those parties just never show up in front of court. They just sort of self-censor. Karyn was talking before about encouraging people to license. I was thinking, actually, like 90% of the people that I talk with, if it's not fair use, they just don't do it because they have no wherewithal to do the licensing. Not because they don't want to pay, it's because the system's complicated and confusing and expensive to navigate. And so I think it's just important to keep those users and creators in mind.
Yeah, I will maybe do a non-copyright last point, just based on the Justice Sotomayor decision and the tone and focus of her decision, as I had kind of mentioned earlier. And that's really, especially in light of other recent Supreme Court cases and decisions, I think having her on the court shows the importance of diversity and difference perspectives, because I think she brought a perspective to the decision, again, that soundly rejected elitism in the analysis and in the art market. And so that's kind of my final thought, that just really shows that you need to have somebody who can speak for those who are not necessarily there. And like I said, the quote from Justice Kagan that, everybody knows what a Warhol is really just not a, is not real. I mean, that's just not a fact. So having somebody who can bring that different perspective was important. And it's unfortunate that this, due to some cases, that might not be something that is going to be continued as strongly as it has been in the past.
Terry.
Thanks, Sandra. Yeah, I think I'll just wrap up. We've mentioned technology a few times, and generative AI. Certainly, we're entering this new world where we'll have computers writing poetry and writing music and all that. But I think, for me, what was really heartening about these decisions was the emphasis and importance of human creativity and the ability of a copyright legal framework to support industries that support human creativity. And I think going forward, hopefully courts continue to recognize the importance of that to society as a whole, and allows that legal framework to continue functioning to support that creativity.
On that note, please join me in thanking the panel.